possible. So it's an honor and a great pleasure for me to introduce to you today's speaker, who is Professor Martti Koskenniemi. Not only because he is an extraordinary scholar and one of those extraordinary scholars whose books are events and are capable to attract and orientate the scholarly debate, producing, for instance, the blossoming of special issues and thematic sessions of academic journals around it. But also because his personal trajectory can be at least as inspiring as his thought and his books. And those of you who were here this morning have first-hand view on this incredible trajectory. So Martti Koskenniemi is Professor Emeritus of International Law at the University of Helsinki and is a leading critical scholar both in theory and history of international law. He is corresponding fellow of the British Academy and a member of the American Academy of Arts and Sciences, and a member of scientific councils and advisory boards of many prestigious academic institutions. He is also director of leading institutes in international law and human rights, like the Eric Castren in Helsinki, and also has been director of ERC and Funded European Projects. He has held several prestigious academic positions in Finland and abroad, at NYU in London, at the London School of Economics, at the University of Melbourne, the University of Cambridge, and several visiting professorships. So this would be enough for an extraordinary scholar, but Professor Koskenniemi has been working also as diplomat for the Finnish Ministry of Foreign Affairs for 16 years. And amongst the many international law assignments that he had, he was a member of the International Law Commission at the UN from 2002 to 2006. So he had received honorary doctorate from the universities of Uppsala, McGill, Frankfurt, Tartu, Brussels, and the European University Institute. And his main publications include From Apology to Utopia, The Structure of International Legal Argument, which had two editions, 1989 and 2005, The Gentle Civilizer of Nations, The Rise and Fall of International Law, 1870-1960, published by Cambridge University Press in 2001, To the Uttermost Parts of the World, of the Earth, for Cambridge University Press, printed in 2021. And his most recent publication is a joint work with Professor David Kennedy at Harvard, and the title is Of Law and the World, Critical Conversation on Power, History, and Political Economy, published for Harvard University Press in 2020. So this is like a summary. So thank you again for being here and for having made all the long trip to Trento. The title of today's talk is Law and War Paradoxes of a Civilizing Process. So I'm finishing here, and thank you once again. Thank you.
Well, thank you for that lovely introduction. Good afternoon, everyone. Thanks for the various departments and their representatives, especially Professor Nicoletti, Manuela, others who have arranged it so that I can be here to speak to you this afternoon. I was originally hoping I could speak standing up in order to see the back row as well. We shall see how this goes. So I have a technical assistant here, and she will try her best to do this. Okay, I will be speaking on war and law, paradoxes of a civilizing project. I'm on record of having written a book some 20 years ago on the gentle civilizer of nations, which presented international law as a whole as a civilizing project of one type. A central aspect of that project was and still is to somehow get rid of or control or discipline war. And that's the topic I'm going to speak about.
Okay.
It's okay now for me.
It's working.
Yeah.
Do you want it higher?
No, it's good. It's good.
Okay, you can manage.
Yeah. Well, now I really feel like a rock star. So, okay. So the paradox. Let me just send a little bit here. Do you hear me?
Yeah.
Okay. The paradox is that never has there been as much law about war, and never has there been such clear evidence of the failure of the disciplining project as today. Law seems to be everywhere in war. Everybody talks about it constantly. Is something a use of force, or is something maybe a special operation? Is something self-defense, or is it aggression? Is someone a combatant, or maybe an illegal fighter, and so on endlessly? Law is everywhere in the way we speak about war. Genocide, for instance. There are places, I've been told, where if a politician isn't accused of being a génocidaire, he is not to be taken seriously. So this legal language has occupied the field of violence and war utterly. What does that mean is the question that I pose here, also in terms of how did the failure of the original project, how did it become possible, and what do we have to learn from that failure? And I start, as usually, with a little bit of a history. So, as I said, international law is a creation, modern international law, of the late 19th century. It's a creation of several projects. One of them is to get rid of the discretion that states in Europe claim they have in order to get to war. Now, we know conventionally that the 19th century European political system was supposed to be based on this idea of balance of power, inaugurated, some say, in 1815 after the Napoleonic Wars among the great powers and the concert of Europe. The balance of power is an anti-legal project. It is an anti-legal project in the specific sense that it invites everyone constantly to maneuver their position in relationship to how other people maneuver their positions. So it cannot be a project of following the rules. Rules are anathema for balance of power. Balance of power relies on everyone constantly maintaining discretion in regard to how other people operate. Now, the First World War, in the consciousness of the first generation of international lawyers, of modern international lawyers, the First World War was an epitomic proof that this system, the system of balance of power, failed. In diplomatic histories and autobiographies, one hears always the story of the July crisis, the crisis that led to the guns of August, that is to say, the beginning of the First World War, as an effort to redress the balance over and over again. So something happened in Sarajevo, which meant that somebody reacted in Austria, which meant that somebody reacted in Russia, which meant that somebody reacted in France, which meant etc. And diplomats were passionately taking the train across Europe in trying to redress the balance, to try to prevent what everybody more or less realized that was coming. Now, whether or not that's true, that was the consciousness with which the diplomats and the lawyers met at Versailles during the peace talks of the First World War. And they wanted to get rid of that. They wanted the international system to be based on rules and not this dangerous system where everybody constantly surveys the operations of others and maneuvers itself by reference to what others do. And you wanted to have an institution that would authoritatively make those decisions that regarded the application of those rules. This is the moment when the issue of the laws of war were established as questions about establishment and application of rules. The rules that were enshrined in the covenant of the League of Nations were very absolute indeed. Article 10 of the League covenant provided that all the members undertake to respect and preserve against external aggression the territorial integrity and political independence of every member. Three Musketeers, all for one, one for all, right? Everybody made that commitment. It's a rule, because if somebody's territorial integrity is threatened, then you, or violated, then you attack. Article 16, a still more powerful rule. Should any member resort to war, then it shall be ipso facto, without any discretion involving, be deemed to have committed an act of war, and all the members shall immediately, right away, merely as the factual realization has taken place that somebody has engaged in war, subject that country to the severance of sanctions, trade and financial relations. So this is tough stuff in legal terms. The rules are absolute, and they address every member of the League in a similar way. Now, the experience is problematic, to say the least. This is a story of the failure of that project in a series of events. The Chaco War in Latin America. So two Latin American countries engaged, they obviously accuse each other of aggression. But most European countries thought, oh, what's Chaco anyway? Where is it? Who? And are we now do we have any relations with them? What should we do with them? No, let's just send a few diplomats to negotiate, and that will go away. It doesn't. The point of the system isn't to universalize a local conflict, far away. So no rule application. Second, Manchuria, the Japanese aggression in Manchuria, 1930, 1931. Okay, so there's an explosion on the Trans-Siberian Railway. The Japanese say that it is Chinese nationalists. The Trans-Siberian Railway had been leased to Japan, and the Chinese nationalists create explosions on the railway. The Japanese say that their operation in Manchuria is just a police action. It's not war, it's a police action. So what does the League do? The League sets up a commission. So this is the infamous Lytton Commission, set up in the early 1932. And the commission sends its representatives to Manchuria. It takes a year for the commission to report back to the League Assembly saying, well, the bombing of Nanjing, the establishment of a puppet government of Manchukuo means that Japan is engaged in war, by which time the Japanese had already completely consolidated their power. So there was nothing to be done. the next story I don't have to tell you too much about. Here is Haile Selassie. This is the Italian aggression on Abyssinia. Okay, so when the aggression takes place, the diplomats in Geneva immediately negotiate the question of sanctions on Italy, as you know. Well, Mussolini immediately reacts as well. If you disrupt the provisions of oil to Italy, which oil obviously was vital for the war effect in Africa, then we shall regard Italy as at war with those countries. So I've gone through the records of the meeting of the neutral and non-aligned countries that took place in Geneva right after, on the day, or on the night after Haile Selassie gave his famous speech in Geneva, appealing for assistance to Ethiopia and for cutting all economic ties as required by Article 16 of the Covenant. And it's a painful reading where I see my countrymen and the countrymen of Sweden, of Switzerland, that was member of Austria, etc., deciding, well, actually, we don't want to think of ourselves as at war in Italy. And Abyssinia, has anybody ever been to Abyssinia? What's the space anyway? Do they really have a country there? I never knew. And are they members of the League? Oh boy. But perhaps more importantly, what was in those years the most important political project and diplomatic project that Geneva diplomats had? Well, it was to prevent the axis of Mussolini and Hitler from being created. And what would have been the clearest way to create just that axis was to isolate Italy. So no serious action. Too dangerous to isolate and to take action against Italy. Well, by this time, the neutral and the non-aligned countries, like my own, that in the 1920s had relied upon the legalism of the League, the position was already given up, and countries like mine started to make bilateral non-aggression pacts with many countries, including, of course, the Soviet Union. With the Rhineland occupation in 1936, everything had already been lost, and people only paid marginal attention. There was nothing to be done. The last thing that the League did was to condemn the Soviet Union in the autumn of 1939, when the Soviet Union attacked Finland. So the point here being that the experience of the functioning of this absolutism, the absolutism of rules, was very discouraging. And we need to understand why. Well, rules are good. Rules are good for a certain number of reasons. They are expected to deter the aggressor. If you have a rule that, you know, if Athos, Porthos, D'Artagnan, they have a rule that one for all for one, so the cardinal's men don't dare to attack them. So they deter. It's not the point to go to war, but to prevent war. They do not allow manipulation. So if you have a rule, the rule is a rule. So you apply the rule. There's no question as to who is aggressing or whom. You just apply the rule. So no political manipulation is possible. They are fast and efficient. You just look at the League Covenant, war. So now I take sanctions. So you don't have to engage in endless conversations in committees as to what should be done. Fast and effective. They are easy to operate. Well, you just read the text, damn it. No need to think about costs and benefits and balance of power, etc. And they treat everyone the same way. They are egalitarian. So in this system, everybody is threatened and empowered by the rules in a similar way. And perhaps most importantly, they do not rely on social cohesion. They do not rely on solidarity. They are automatically applicable in what kind of a circumstance, whether between lovers or persons who hate each other. If you have a rule, then you just apply the rule. It doesn't, nothing else is needed. Unfortunately, rules are bad. Rules are very bad. Why? Well, because the Chaco War, they generalize any conflict. In the League in the 1920s, there was no willingness, and we can understand why there would be no willingness. The First World had just been over, to engage in another large war for this marginal place. They ignore circumstances. Now, here's a personal story. Students always like war stories. So one of the tasks I was engaged in while I was still the head of the public international law section in the Finnish Foreign Ministry was to take part in the Finnish Security Council delegation in 1989, 1990, when Finland was a member of the Security Council. Now, in August 1990, Iraq attacked Kuwait. 6th of August 1990, I had to tragically leave my summer vacation and come back to New York. And a system of sanctions was set up against Iraq. A system of sanctions. Finland was one of the countries which in the council, with voice of confidence, says, yes, now we apply the UN Charter and we apply sanctions. Now, then you turn to the Jordanian ambassador. Actually, the Jordanian ambassador didn't say anything. So, but then after the meetings were over, the Jordanian ambassador knocked on the door and saying, you don't seriously think that we would take action against Saddam. It's one thing for Finland to speak with a voice of confidence about what happens in the Middle East and that we shall disturb our trade, which is about 0.7% of Finnish trade, whereas with Jordan, which gets all its oil from Iraq, it's another thing. So in a collective effort of this, not everybody is in the same situation. So you're a country far away from the country targeted by these measures. You're a neighbor. And so silently, the UN allowed Iraq's neighbors not really to employ the sanctions. There is in the UN Charter, there is a provision for countries that might be hurt by participating in collective action. It's a solidarity measure, Article 53, if I recall correctly. And so the idea is that those who are mostly hurt by the sanctions, they will get assistance from others. And did Jordania get any assistance from others? Well, the conversation, as far as I know, is still continuing about what kind of help they would receive. So they are bad because they ignore circumstances. They don't take into account the situation of Jordan in regard to Iraq, or for that matter, Finland with regard to Russia. They are dangerous to apply. Italy, oops, everybody all of a sudden at war with Italy. No, you don't want that. And that's like Jordan didn't want to be in conflict with Iraq. They put countries in a de facto different position. Again, the same issue. In the first event or series of events in the UN where sanctions were widely employed, which was the case of Rhodesia, the white racist government in Rhodesia having taken over, the UN sets up sanctions. At that time, the frontline states, so-called, did receive assistance from UN development funds because they were obviously in a different position, the African countries surrounding Rhodesia or Zimbabwe from today, with Iraq no longer the same. Which is to say, they rely on social cohesion. They actually rely on the willingness of countries to come to assistance of those who are mostly suffering from taking action. And so the issue is that rules are good and bad. And it depends on a situation a little bit, which side and any particular moment you are, what your situation is. And therefore, in the UN Charter, the system of the covenant was set aside. In the UN, there are no longer any absolute rules in the UN's war system. Here are two of the most important rules of the war system, which, as you can see, are worded in a very different way. The main rule, Article 2, Paragraph 4, all members shall refrain not from war, but from the threat or use of force against the territorial integrity or political independence of anyone. That is in order to get away from the Japan situation, where Japan, or Russia for that matter, says, oh, it's not war, it is something else. It is a police operation. It is a special operation. The UN now allows countries to think about what does it look like. If there is threat or use of force, then the system applies as a whole. But the central rule is that the Security Council shall decide. It is for the Security Council to determine any threat to the peace and then make recommendations. You see how soft this language now is. And it's not for individual countries. You can't just go as you want. It's the Council. The Council will first have a diplomatic negotiation. How does the Council decide? Of course, as you know, there are the permanent five. And of course, in a sense, the system of balance of power from the 19th century has been imported inside the Security Council in the negotiations between the P5, the permanent five, and they shall make recommendations or decide what measures shall be taken. If they decide, as the jargon goes, under Chapter 7, the Chapter 7 of the Charter has to do with maintenance of peace and security, then these decisions are supposed to be binding. And so if you noticed, the Security Council resolution, which was passed just 2 days ago in New York, having to do with Gaza, was not made under Chapter 7. So the members were very rapidly saying, well, it's a non-binding resolution. So anyway, so it's a way softer thing. And it's about discretion now, and no longer rules. No, what about discretion? So two cases. The discretion was used in Kosovo. So here is the tower, the TV center of Belgrade, burning at the time of the NATO intervention in Kosovo. You may recall, towards the end of the Yugoslavian wars, Serbian forces were moving into Kosovo. There was evidence of some atrocities in the city of Račak. And the fear among the Western countries was that Srebrenica or something of the kind would be repeated in Kosovo as well. And so the Western countries went to the Security Council saying, well, we need to now take action against Serbia. And Serbia's allies, Russia and China, obviously said, no way. And so Western diplomats looked at each other and decided, well, if it's illegal, it nevertheless must be legitimate. And even I found myself responding to a newspaper, to a journalist saying, well, yes, of course it's illegal, but yes, it's legitimate. Later on, I was wondering, what on earth might I have meant when I said that? But I suppose that point is to say that you know what the law says, so you're a good professional, but you also have a your heart in the right place. So whether that was successful or not, Belgrade was bombed. So illegal, but legitimate. So there. But what about other situations? So Iraq, 2003. This time, again, the US wants to use war because of weapons of mass destruction. You remember the evidence on weapons of mass destruction. Many of the council members were not convinced. And so illegal, but legitimate. Oh, well, discretion. People disagree on these things. The thing about discretion is that it leaves a disagreement hanging out there. Was it really legitimate use of force, or was it imperial aggression on a weaker partner? The 1990s was the period of great liberal hubris about the international world. The liberal world order was being constructed, and liberal human rights values and humanitarian values were supposed to be advanced. And so the Kosovo incident, which made many people unhappy. Yeah, well, was it legitimate? Maybe, but certainly was not legal. And so committees were set up in many European countries, in which some of which I participated, also looking into the possibilities of a charter amendment or a creative reinterpretation of the charter so as to allow humanitarian intervention, so-called. In 2005, in a declaration, the heads of state and government in the UN declared that it was sometimes possible to intervene against the sovereignty and independence of a state in case the state itself could not see to the security of its population. This was called responsibility to protect. It was based on a series of reports earlier in the 2000s created by liberal lawyers in order to enable a process, if not a fully legal process, nevertheless a legitimate process to use force for humanitarian reasons. And there was a moment, this was the peak liberal victory, when at this resolution, also China and Russia agreed for the possibility of intervention in certain cases. The first and the last application of this paragraph of this decision was made in the context of the Libyan situation in 2011, when Colonel Gaddafi, in the course of a civil war in Libya, was threatening to carry out atrocities in the city of Benghazi. And the Security Council decided, on the basis of responsibility to protect, to authorize the NATO to take action to prevent that atrocity. NATO commander said, "Thank you very much," and sat down and interpreted that the only way to prevent this thing is to carry out regime change in Libya, as a result of which, obviously, Colonel Gaddafi was killed, and the whole country was thrown into utter confusion and violence, with the result that the ambassadors of China and Russia said in the Security Council, "That's it. We are never, ever going to allow you to do this, because, as we thought, you would anyway interpret this authorization in accordance with your somber imperial plans." And of course, in Syria, we know that the question of a responsibility to protect humanitarian intervention has no longer been on the agenda. So today we are debating self-defense. Here is the Israeli team in the International Court of Justice, or part of it, claiming that in Gaza, Israel is exercising its inherent right of self-defense. Here is the Russian ambassador in February 2022 claiming that Russia is exercising its inherent right of self-defense in Donetsk and Luhansk because of the coming atrocities by the Ukrainians. Here is the rule from Article 51 of the UN Charter, which enshrines the inherent right of individual and collective self-defense if an armed attack occurs against a member state. Now, why is it that the UN hasn't simply prohibited war? Why is it that this swords to plowshares isn't a reality? Well, now imagine that one day somebody in the UN, or everybody in the UN would, in a fit of some disease, decide, okay, now we shall prohibit war. War shall be prohibited. It's a really great rule, isn't it? Why isn't it there? Well, you know the reason why. Because if you enact that rule, this means that many countries will no longer invest in weapons and large armies. They will much rather invest in childcare centers and social services and etc. because war is now prohibited. But you also know that some countries, especially the neighbor countries of those who no longer invest in military other things, just wait a while until they attack their weaker neighbor, a neighbor that made itself weaker because it no longer believed in war. So you have to allow war, at least for one reason, if only that one reason. Why? Self-defense. Well, but self-defense, if you examine diplomatic history from the time of Lorenzo de' Medici to the present, you will see that there hasn't been a war where where the aggressor actually usually hasn't referred to its right of self-defense, maybe preemptive self-defense, because that my neighbor is such a violent partner and their leadership is such an unacceptably militarist. We have to take action before they take, because otherwise it's too late. So you can't just enact a rule either that says that you can never go to war apart from self-defense, because if you open the door a little to self-defense, then the door is wholly open. Because nobody can from the outside say what you need to do for self-defense. You're a sovereign country. Your sovereignty, in some essential sense, has to do with your own ability to decide what it is that you need for self-defense. Okay, so the diplomats, of course, in San Francisco knew this. So what they wanted to do, it was to try to close the damn door that is so easily blown open by any wind of war. And so they added these words: if an armed attack occurs. Now, this becomes a very rule-like provision, only if an armed attack occurs. So it's kind of an objective, it requires an objective evaluation. You send the fact-finding mission. Did the attack occur? Well, actually, people would say, military experts, well, often this is a time of missiles and nuclear missiles. So, and while I was still in the foreign ministry, I remember this meeting we had at the time when the Euro missiles were being introduced in Germany. And Russians, at the time Soviets in Leningrad, were planning all kinds of military installations to preempt the Euro missiles from attacking Soviet territory. And everybody realized that they would have to fly over Finnish territory, wouldn't they? And that would be a violation of Finnish territory by Russian missiles. So we don't want that, But how do you prevent that? Well, you can't prevent that if only an armed attack occurs. So if once the missile is there on the Finnish eastern frontier, you're already lost. And so you have to attack them there anyway. It's a well-known dilemma. So Judge Schwebel in the International Court of Justice in the threat or use of nuclear weapons case in 1996 made the same argument. So nuclear weapons cannot be prohibited. Self-defense cannot mean what it seems to mean here, because imagine the scenario that terrorists hijack a submarine, and they take this submarine to the Arctic. It has nuclear missiles, and your military experts, he was speaking of the American president, the experts of the American president come to Washington and say to the president that there is this submarine. And we know now from inside information that those missiles are targeted against us. And then the president says, oh, you must hit now. But then the legal advisor comes in, sorry, President, but the UN Charter says only once an armed attack occurs. But is it realistic to expect the American president to sacrifice the population of Washington or New York or any other place because in order to show loyalty for those words? Well, no. The president would say, attack now, obviously. And to hell with Article 51 of the Charter. And if I were his legal advisor, that's what I would say. Anyway, final frontier today. So all of this, what I've been explaining to you, is about the law ad bellum, the jus ad bellum, the right to go to war, the difficulties of limiting that right to go to war. And so people look elsewhere. Maybe we can't do, at least we can do a criminal law that then helps us out of these problems. Now, why would you think criminal law would be helpful? Now, if there are any criminologists or criminal lawyers here, they would know very well a series of justifications there are given to why criminal law, modern criminal law exists. Why punish? So the standard liberal response has been, well, not to make revenge. That's old-fashioned. We don't think in those. We deter. So the whole of the criminal law, its point is not to put people in prison. Its point is to make our cities safe and people act in accordance with rules, to deter. Now, in 1998, the Rome Treaty, the establishment of the International Criminal Court, and all the ensuing debate about genocide, crimes against humanity, war crimes, etc. Now, does that deter? Now, imagine this scenario. There's been a civil war or hatred among these two populations for decades. They say it's existed for centuries. It's an existential opposition between these. And the other countries' population has killed off a number of these people in the other country. And they've decided, now we can hit. And they have their Kalashnikovs or whatever they have. The fight has been bad already. They are all in the jungle. And then one morning, they rise from the forest, and there's the village. And they look at each other. We are going to kill all of them now. And then somebody remembers, but there is the International Criminal Court. And we may have to go to prison in Stockholm or in Sweden somewhere. Let's go home. Is that a psychologically plausible scenario, you think? That they will just put their Kalashnikovs in the bushes where they 5 minutes ago were thinking of going to the village and killing all of them? Well, it's up to you to decide. Then revenge. It's really hard when I interview international criminal lawyers to think in terms of revenge. I think revenge lies there but in terms of having a rational debate on revenge, no. Instead, what they say is that, no, Martti, you shouldn't take those justifications of modern criminology so seriously. This is about the symbolic value of this. By international criminal law, the international community declares the most important values of the international that there are in the world. Now, if somebody doesn't know that the massive killing of the innocent is not a good thing, how much is added to that person's knowledge by saying, and besides, it's now prohibited by the International Criminal Court? So what is the symbolic value of that? Well, we can have a conversation on that. But many don't believe in the symbolic question or the dubious psychological generalizations about some catharsis that the victims or the families of the victims will have. I certainly am not an expert in those kinds of speculation. To create a history, so Nuremberg, so lawyers who are knowledgeable about and historians about Nuremberg, they always say that, well, Nuremberg, of course, was not very successful as an incident of the application of criminal law. It was partly retrospective legislation. It was very partial. Only some things were focused on, other things were forgotten conveniently, etc. And I can't go into details. But nevertheless, the massive archive, it created a history. So we wouldn't know about these events if it weren't the case. Now, and what sort of a history did Nuremberg create? So it was a history in which the forest of Katyn was just a place for birds to sing and trees to grow. It was a history where there was no plan, no allied plan to invade Norway before the neutral Norway, before the Germans invaded neutral Norway, and so on. In the famous reel that shows the British troops come into Bergen-Belsen and with these trucks, these bodies into mass graves, the voice that spoke behind, because it was watched in Nuremberg, the voice that spoke behind spoke of innocent civilians. Innocent civilians. Is that the history? Well, you needed another trial. You needed the Eichmann trial to point out that it was not just some innocent civilians. Well, the problem about writing a history in the direct aftermath of a series of events usually cannot do the work properly. During the Barbie trial in France in 1987, the French historians were adamantly against this trial because it's not the task of a criminal process to tell the story of what the French did, what the Germans did in France, what happened in France. The trial was supposed to, when it was explained to the great public, not so much being about Barbie himself, but about telling the way in which Barbie had captured and killed the resistance fighter Jean Moulin, and that the Barbie trial was a moment to celebrate the resistance. What happened? Well, it was found out when the Barbie trial was prepared that the torture and killing of Barbie was a war crime. And war crimes, the statute of limitations had struck at war crimes. Instead, something else had happened. Barbie had captured the children of the village of Isieux, Les Enfants d'Isieux, if you've seen the film, and taken them to Auschwitz. And that was a crime against humanity. And no statute of limitations in France applied to that. So that the trial wasn't a trial about French heroism in the resistance, but instead a trial of French complicity in the Holocaust. Oops. Anyway, history isn't such an easy thing. The last thing about history is that international criminal lawyers often think that the accused is silent. Well, as a famous, now dead, international criminal lawyer Jacques Vergès put it, the accused often is not silenced. Vergès, in his wonderful book, La stratégie judiciaire, makes this distinction between a trial of connivance and a trial of rupture. What is a trial of connivance? It is a trial where the accused and the legal team of the accused connive, that is to say, agree to the description that the prosecution produces and merely denies that the accused did the thing. So, for instance, yes, of course, the murder took place, but my client was on train to the other direction at the time. So that's a regular trial of connivance. You agree to the facts, but you disagree with whether your guy did it. Now, Vergès pointed out that there are other kinds of trials. Trial of rupture, where the accused denies the very frame given by the accused or the court to Socrates. So the Athenian elite accused Socrates of corrupting Athenian youth by his speeches on the forum. And they offered him the possibility of recanting, of apologizing to the elites for what he had said against the wonderful elites. Well, but he didn't connive. Instead, he said, well, bring me the poison. And do we now remember the members of the Athenian elites or Socrates? So Vergès would say, this is a moment where you can turn the tables, and instead of accepting the frame given to you by the court and the law, you say the court is the crime, the law is the crime. When Vergès was Barbi's legal advisor in the Barbie trial, he brought two lawyers with him, an Algerian lawyer and a Nigerian from Niger, a lawyer. And neither one spent any time in trying to defend Barbie, but instead they tried to show that everything that France did during the Algerian war and in Niger, all the executions, all the torture, was exactly what Barbie had done in Lyon. So you see, Vergès tried to turn the tables against France. Milosevic, so Vergès became also the lawyer, unsurprisingly, of Milosevic. And if you listen to the Milosevic trial, you realize that what Milosevic was saying was not saying, I'm innocent. Instead, he was saying, this is a show trial, and that the Americans and the West have put this up to continue the age-old imperial activities on the Balkans against the Serbs and their kin. And it's just one part of it. Now, Milosevic, of course, died during the trial, following his strategy or his execution of the strategy. I didn't think he was a Socrates, really, but you can see the point. So this is the last slide, and this is also where I will end, so you will be relieved in a moment. So I want to say that applying law in a situation of war is really difficult. Now, law is really good as, for instance, an instrument to control traffic. So you have a traffic sign 70. And you want there to be such traffic signs, and you don't want any discretion. Why is it? Well, let's think about this. Now, imagine that there were a crossing somewhere in a desert, and in which full visibility all directions, and there would be this sign, 70 miles an hour or 70 kilometers an hour. and you would come there, you would see there's nothing in any direction. And so you would pass. But there was a policeman. And you do get a ticket. And you say, oh no, but you know, I could see there was no danger for anyone. Now imagine that the rule was instead, you must way down to 70, that it was instead, you can pass as fast as you can, depending on your assessment of whether danger ensues or not. Now, the amount of the dead in the roads would be 1,000-fold. So you don't want that. And more importantly, you don't want that, even if the 70 miles per hour creates a little inconvenience for the person, because it may be true that there was no car coming in. And it may be true that she really had a hurry to get the train. It may be true. But you don't want to allow them to think for themselves. Why? Well, because the existence of the rule is so much more important than any single interest that anyone has in violating that rule. That is to say, in the thousands upon thousands upon thousands of cases where it's really good that you have that 70 miles an hour limit, it's so much more important than the little inconvenience that you missed the train, but you know, the next train comes on. And so it doesn't create a revolution. You don't, or you might want to try, but I don't think the rules of the road will change. Now imagine war. Imagine a situation where somebody really thinks we have to do this. People are killed every day around us. Our people are killed. We have to do something. We have to defend the patria. We have to defend them. We have to sort this thing out. We've invested massively in military terms. And now you say we can't do that. Now the tables are turned. Here, the little inconvenience in the first example, the little inconvenience for the driver doesn't measure up to the great social interest in that people generally abide by the rule. But here, every unjustified application of the rule is a scandal. Every need to act is more intense than the need to honor the abstract form of the rule that exists in the Charter of the UN, which everybody has all the time been violating anyway, and on which people don't have a realistic perspective that it will be honored much more in the future. Okay, so what I want to say is not that law and war cannot come together. What I want to say is that law and war are strategic instruments with which you can do some things, but you can't do other things. Today, that the language of law has expanded everywhere in war itself, law has become a part of attacking and defending. That's why we have these cases in the International Court of Justice. We call it lawfare. Another way to wage war by using the legal argument once you do it. Again, I'm not saying you shouldn't do it. I'm not saying even if you could not do it. I'm saying war is a part of society, just like law is, and they interpenetrate in complex ways, so that to legislate in any clear way on war is impossible in a world where we don't think in a similar way, where fundamental values, interests, preferences are at stake on a daily basis. We can use it a little bit here and a little bit there, but otherwise we are engaged in lawfare, and that is to say, You have lawyers waiting there on the taxi car principle for clients from various countries exercising violence, wanting to use them. And then it becomes a question merely of the lawyer. Who will you take as your client? Thank you.
Thank you. Thank you so much for this thought-provocative and even mind-shaking talk. I'm sure that we all have many questions or doubts or curiosity. So I would open the floor. Professor Faitini.
Thank you very much, Professor Koskenniemi. Marco Faitini, International Law, the School of Law. Thank you so much for your talk. I was, So in this journey, I was struck by the fact that you did not mention directly the use in IHL. So you mentioned, of course, use at bellum, then the criminal law frontier. And I was wondering whether you dropped the use in bellum because you believe it has no traction, or whether you believe that through military manuals, troops, commander on the field, also IHL might shape behavior in warfare. And then I would have anecdotal evidence. I also have a story to tell because you mentioned the deterrence effect of criminal law. And I was working for a while at the International Criminal Court, and at some point we were working on Uganda, and we had direct evidence that the Lord Resistance Army were seeking legal advice as to what to do with their case in The Hague. So that was very striking because we had evidence that they took into account the fact that a case was ongoing in The Hague. So the deterrence effect, perhaps from time to time, is unexpected in warfare. So thank you very much for your talk. That was wonderful.
Thank you very much. Well, I had actually a slide on so-called international humanitarian law in the earlier version, but I thought that, no, this will go too far. And and I have views on IHL, or, well, the laws of war, as I like to call them. The euphemism of humanitarian law is a little bit displeasing to me. So international humanitarian law and international criminal law have recently come very close together. And I am dubious of that process. I have great sympathy and admiration to my friends in the ICRC, for instance, who work in terrible circumstances to do the best in a difficult situation to help the victims of war. But I'm also dubious a little bit about the conceptual coherence of the laws of war. So at the heart of the laws of war, as I like to call them, IHL, humanitarian law, at its heart is the principle of distinction, distinguishing between combatants and civilians. And that distinction, I have you know, is of very recent inheritance. A historian colleague of mine said that in the international legal field, it appeared for the first time in 1923 in a draft convention on aerial warfare. And one can understand why aerial warfare would be it up to that moment, but also long thereafter. The question of civilians engaged in industrial operations, for example, their status had been under a lot of debate. So it seems nowadays clear that if you are working for a factory that produces weapons or ammunition, then you are a legitimate target. But today in these massive wars, what industry isn't connected with the operations of the war in some way or another? In the late 19th century, with urbanization and massive industrialization, the language addressed enemy populations. So what we now call as civilians are enemy populations, and they would be targeted as any other, because the reasoning at that time was that the whole enemy population is in one way or another engaged, which is the lesson that 19th century lawyers drew from the French Revolutionary Wars, where that was the part of the French ideology, in fact. And to keep the concept of civilian untainted from association with military operations has always been really difficult. And if you want to know the difficulty, you can look at the judgment of the Israeli Court of Justice, operating as the High Court of Justice in the Palestine occupied territories, where at the time of Judge Barak, the question of targeted killings arose. And Judge Barak, whom I have immense admiration for, in a series of tortured paragraphs there, imagined the situation where a Palestinian person lives at home, makes a breakfast for their family, takes the kids to the kindergarten, returns home, and starts to prepare a bomb. So is that person a legitimate target? Is that a combatant or not a combatant? Well, I don't know. But having to ask questions like that is one of the reasons for why I didn't take the IHL slide here, but also one of the reasons for why I've never taught this part of international law, because I would want to not lose my credibility in front of my students so rapidly. But as I said, I know that as a practice of humanitarianism, of the ICRC, of the Médecins Sans Frontières, I have immense admiration for these people, many of whom I know, I am in constant debate with. It's just that the lawyer in me finds that this is not a field in which I can make a useful contribution.
Was there a question?
Thank you, Professor, for your wonderful presentation. I am Giovanni Koskenniemi. So, thank you. I am Giovanni Koskenniemi. I am a PhD researcher at the European University Institute. I have a brief comment and two questions about your presentation. First comment is that I think that what you're pointing out in your presentation is the lack of a supranational coercive force to apply international law, which is something that only utopian thinkers might imagine as today. And the two questions are, the first is related to what you said about the case of Kosovo and the case in which an intervention and according to which an intervention might be illegal but still legitimate. Now, let's imagine an hypothetical scenario in which a coalition of countries, maybe led by China, were to intervene in the ongoing war in Palestine, in Gaza against Israel. Would you still define it as an illegal but legitimate operation? And the second question is really obvious, and it's of course linked to what is happening at the International Court of Justice. Would you define what Israel is doing in Gaza as a genocide? If so, yes. If not, why?
Yeah. Thank you. So I was asked the question whether I could, what would I say in the imagined scenario where China and maybe the BRICS countries would intervene against Israel, I suppose, in Gaza. Would I think it's illegal but legitimate? So the lawyer in me obviously says that it's illegal. No question about that. Now, what about my political opinions? I have to say, I'm pretty bored about my political opinions. So I'm much more interesting as a technical expert in international law than having these regular kind of social democratic, pinkish political opinions about things. And so Yeah, well, if we would have to talk about the manner of the intervention and the costs and benefits and all that. So much for the first question. The second question: is Israel committing genocide or not? Well, as you know, the issue of genocide has to do not only with the number of people having been killed, but also establishment that there has been an intent to eradicate a population owing to its ethnic, political, religious, etc. composition. Now, I don't think that I can identify in Israeli leadership that sort of an intent. For having, like you, I suppose, Giovanni, having followed the trials, there's been a lot of talk. So South Africa did so much better than the Israeli, and so they produced a lot of evidence of high Israeli officials using language connoting genocide. So I would say, if I were Netanyahu, I would kick those people immediately from government. It would take, I think, a stretch of imagination for me to believe that there is such an intent to eradicate that would fulfill the criterion of genocide. But again, I have to say that so much depends on technical details and political opinions that when I engage in this kind of a professional discourse, I would feel much better in doing that as the lawyer of a client, in which case I can know what my discourse is aimed at, than producing in front of you the from the cathedral a legal response to a question which hundreds, if not thousands, of people in the world are presently thinking of. I know a lot and I'm pretty skillful as a technical lawyer, but I don't have a response that I would with good conscience give to you, not knowing whether that I would be a lawyer either for the Israeli side or for the Palestinian side. If you have money and you want to enlist me on either side, then I can give you a discourse.
Other questions or comments?
Thank you very much. I have not a very elaborate question because I'm still thinking what you said, but I think I have three maybe interrelated questions. So the first one is, if I understand correctly, especially also with regard to your last slide, like law is bad for governing wars whenever there is a discrepancy between legitimacy and legality. So in the traffic example, legitimacy and legality kind of go together, and then the other one not. So that's the first one. The second one is, since there is no prohibition of war, and the reason that you gave is that we basically mistrust our neighbors, right? Can law play a role in diminishing this mistrust, or is it too much grounded in our failures, humans, to be like more, like, I don't know, better or rational, or however you put it? And then picking up on what you said, you mentioned supranationality. And is this like a trust also a reason why there is no supranationality? Why there is no supranational authority? Thank you.
Well, so law and legitimacy first. So I am always a little bit dubious what people mean when they speak about legitimacy, including when I speak about legitimacy. But there's always an audience that expects that that issue is addressed as well. It has to do with, I suppose, acceptability of some action, and irrespectively of whatever legal rules are there. On the other hand, legal rules contribute to what we think of as legitimate as well. So legitimacy can be received through following of rules, Weber, but also through other kinds of argumentation. And so in this recent book of Law and the World, where David Kennedy and I have conversations on various issues of politics and power and political economy and history. So we do deal with the legitimacy issue in a tortured way a little bit. So neither one of us is happy with that language. There is one clear significance to that language, and that is a suggestion of moving the debate, including authoritative decision making on something, from lawyers to political scientists or politicians. And sometimes that suggestion is correct. Sometimes I, as a lawyer, think that no, I mean, we can deal with this. Why give it to political scientists and their obscure language of legitimacy? These are fighting words, law and legitimacy, and we engage with them. My idea is not, or my intention is not to prohibit speaking from legitimacy. It's a very relativistic notion. What one person thinks of as legitimate, another person doesn't think of as legitimate. But then again, we live in a relativistic world, so we have to be able to talk about these things, with which I suppose I come to trust and so before I come to trust and whether cooperation, can law diminish this trust, let me just say that I don't think that law's power lies in legitimating anything. Contra Max Weber. I don't think that. I think law's power is twofold. One, law frames to us a world in which we act. And those of you in the international relations field who are familiar with constructivism and all that, they know what I mean. So law gives to us notions such as sovereignty and property and intervention and boundary, etc., etc., etc. Law lays out a whole world within which political choices are made, within which, more importantly, interests can be identified as belonging to somebody. Property. So capitalism relies on a legal notion of property, etc. I can't pursue this. It would be another lecture, etc. So framing, that's where law's power lies on the other. The second place where law's power lies is what I call, it's a bad word, articulative power. It is the power of somebody to be able to articulate something as a legal truth in a situation where another person must yield to it. That's a very different kind of a power. It is the power that lawyers have in situations where law is expected to decide the distribution of resources or to decide whatever other thing needs to be decided. So law's power is the power which is inducted into law students in law schools, and which they feel still in the first years of the law school, when they feel that they become adults and they start to speak the language of the law and in contexts in which other people are expected to yield. So that's a very personal power. It's a power of the law in discourse, where it reproduces authority and hierarchy. And so I leave legitimacy to moral theorists and analytical political philosophers, and I don't want to say much more about that. Can law diminish this trust? Yes, I think it can. And for a long time, when I was in the service of my ministry, so I was engaged in the OSCE very often, so the Organization of Security and Cooperation here, CSCE. Conflict building measures was a big theme that we engaged in there, and things were achieved. And law was a part of that theme. Law provided a common discourse with which we could address each other across the Iron Curtain and bring. So it doesn't solve crises, but it creates a forum in which people can meet each other. They have a legitimate role in saying things, articulating their preferences, and you come to understand each other. Having sat in, so the one thing I miss from diplomacy, having come to the university, is that the sense of solidarity and comradeship that exists in a long international convention. I was involved in the law of the sea negotiations, for instance, not quite from the beginning, but from the late part, and then to the implementation negotiations, sitting endless hours with colleagues from all over the place. And we were able to bring things together. The politicians were still quarreling, but the lawyers were able to bring things together. Now, all of this, there's lots of ifs and buts here. It doesn't operate automatically. You have to know what you're doing when you create cooperation. But law is, as they say, a common language. And so a common language also brings with it a common understanding of the world. And a common understanding may sometimes bring solidarity, diminished discord. And so I suppose that's the response to the third question. So trust, how is trust created? So I mean, in our European societies with far right, especially with post-truth, with the social media as it is, so trust in public authorities has eroded now for a number of years, and that is a big problem. I think there are better minds than mine thinking there are how do you recreate that trust once it's gone? So when the vase falls and gets broken, you can't just imagine that it wasn't broken. If it's broken and it's not there. You have to work for years and maybe decades in order to create that trust between people whose very frame of understanding the world has been broken into pieces like this vase.
I think we have probably the last question.
I wanted to ask something about the use of the term war in the legal framework. So if you look at the Geneva Conventions and also to the UN Charter, what the conventions refer to are armed conflicts for the threat or the use of war. And I think this is a choice in a certain sense, because war is a term that brings with it the idea of exceptionalism, so the idea of justification. So states consider to being justified in doing everything they wanted to for considering war as an emergency, so a situation of emergency, even if depended on the choice of the state in a certain sense. So, and also this brought with it some prerogatives that are recognized legally, for example, prerogatives that could be considered as belligerent rights, such as in naval warfare. And the things that I wanted to ask is, don't you think that even if there are some precise rules that are hard to apply, connected to IHL and also to self-defense, for example, there's still a value of delegitimizing the recourse to the use of force. At least the value is to eliminate this idea of exceptionalism, to say if a state recourse to the use of force is doing something wrong and does not have prerogatives, and even if in this circumstance international law applies. Thank you.
So first, war. So the fact that in the UN Charter, the Charter doesn't speak about war. That's a direct reference to the failure of the League experiment. So the League spoke about the war. The Japanese example that I gave you, the Japanese were just engaged in a police operation. So that was in everybody's mind. So the word war is avoided because it has this ambiguity. Now, whether the solution to use these other terms is better or not, I leave that